My name is Sofia Fradinska-Kovalchuk and I'm an IT lawyer. This is my personal vlog regarding IT legal news that made back to ІТ-бізнес, which provides services in the EU, UK and the USA. Today we'd like to review the most important, in my opinion, new GDPR EDPB Guidelines adopted from January to July 2023. As you know, summer is a hot time for privacy professionals to update online privacy policies on the websites. First of all, where to search for European Data Protection Board guidelines. There is an official website at the following link where European Data Protection Board posts all its guidelines, recommendations, and best practices. You can find it at the following link. And the second one, there is an official legislative website, EuroLex, where you can find the official text of General Data Protection Regulation, following this link. In my opinion, I've decided to analyze these four main new EDPB guidelines adopted from January to July 2023. First of all, I would like to talk regarding a report of the work undertaken by the Cookie Banners Task Force, which you can find the full text at the following link, which was adopted on 17th January 2023. First of all, what shall you check? Check whether your cookie banners on the website meet all the latest requirements. There shall be a refuse, reject, not consent option button on the same layer with the consent button. Shall be no pre-ticket boxes on the second layer of the cookie banner, example after the user clicked on the settings button of the first layer. No deceptive button colors and deceptive button contrast. Accurately classify as essential or strictly necessary cookies. Put easily accessible solutions allowing users to withdraw their consent at any time, such as an icon or a link placed on a visible and standardized place. The second one is a guideline on the interplay between the application of Article 3 and the provisions on international transfers as per Chapter 5 of the GDPR. You can find the full text at the following link. These guidelines, version 2 was adopted on 24th February 2023. The main provisions from these guidelines, on my subjective opinion. A transfer implies that personal data are sent or made available by a controller processor, which regarding the given processing is subject to the GDPR pursuant to Article 3 to a different controller or processor importer in the third country, regardless of whether or not this importer is subject to the GDPR in respect of the given processing or to an international organization. As a consequence, the exporter needs to comply with the conditions of Chapter 5 and frame the transfer by using one of the instruments that aimed at protecting personal data after they have been transferred to a third country or an international organization. These instruments include an adequacy decision adopted by the European Commission, or, in the absence of such adequate level of protection, the implementation of the exporter, controller, or processor of appropriate safeguards as provided for in Article 46. The main types of transfer instruments listed in Article 46 are standard contractual clauses, binding corporate rules, codes of conduct, certification mechanisms, ad hoc contractual clauses, international agreements, administrative arrangements. The next one guideline I would like to talk is Guideline on Personal Data Breach Notification under GDPR, the second version of which was adopted on 4th April 2023. The full text you can find at the following link. The main paragraph for me is breaches at non-EU establishments, where control and not is established in the European Union is subject to Article 3, subparagraph 2, Article 3, subparagraph 3, GDPR, and experiences a breach, it is therefore still bound by the notification obligations under Articles 33 and 34 GDPR. Article 27 GDPR requires a controller and a processor to designate a representative in the EU, where Article 3, subsection 2, GDPR applies. However, the mere presence of a representative in a member state does not trigger the one-stop-shop system. For this reason, the breach will need to be notified to every supervisory authority for which affected data subjects reside in their member state. These notifications shall be the responsibility of the controller. Similarly, where a processor is subject to Article 3, subsection 2 GDPR, it will be bound by the obligations on processors of particular relevance here, the duty to notify a breach to the controller under Articles 33 to GDPR. And the next one It's a guidelines on that data subject rights of access, the full text of which can be found at the following link, and the second version of which was adopted at 17th April 2023. The main provision from these guidelines, in my subjective opinion, is regarding different means to provide access. When making an access request, the data subject are entitled to receive a copy of their data undergoing processing pursuant to Article 15, subsection 3, together with the supplementary information, which is considered as the main modality for providing access to the personal data. However, in some circumstances, it could be appropriate for the controller to provide access through the ways other than providing a copy. Such non-permanent modalities of access to the data could be, for example, oral information, inspection of files, on-site or remote access without possibility to download. A controller is not obliged to provide the information through other ways than providing a copy, but should take a reasonable approach when considering such a request. Giving access through other ways than providing a copy does not preclude the data subject from the right to also have a copy unless they choose not to. The controller may choose, depending on the situation at hand, to provide a copy of the data undergoing processing together with the supplementary information in different ways, for example, by email, physical mail, or by the use of a self-service tool. If the data subject makes a request by electronic means, and unless otherwise requested by the data subject, the information shall be provided in a commonly used electronic form as stated in Article 15, subsection 3. In any case, the controller has to consider appropriate technical and organizational measures, including adequate encryption when providing information via email or online self-service tools. These were the four main, in my subjective opinion, EDPB guidelines, which were adopted by EDPB during January-July 2023. If you find this information useful, you can read all these guidelines at the following links on the official website of EDPB. Thank you for your attention. Also, I would like to mention that I am an IT lawyer in Ukraine, and if you support Ukraine, please donate money at the following funds. It's International Charitable Fund Come Back Alive. The link is here, and Blue Pond's special account to raise funds for Ukrainians armed forces, and you can find the link here. Ask you to stand with Ukraine, support Ukraine, and close the sky over Ukraine. Thank you for your attention.